I'd like to ask the Minister for Policy and Reform what assessment has been made of the potential impact on the islands of any disruption to the flow of personal data between the UK and the EU in the event of a no-deal Brexit, as highlighted in Section 9 of the Yellowhammer documents, and if he will make a statement.
Minister for Policy and Reform, Mr Thomas, to reply.
Thank you, Mr President. One of the assumptions in the Operation Yellowhammer, Her Majesty's Government's reasonable worst-case planning assumptions as published by the UK Government on 11th of September, is indeed that in the event of a no-deal Brexit, there could be potential for disruption to the flow of personal data between the UK and the EU where an alternative legal basis transfer is not in place. To assess the impact on the Isle of Man of the potential difficulties between the UK and EU is challenging. However, this is one area where the island may be in a more favourable position than the UK. As honourable members know, the Isle of Man has a so-called adequacy decision from the EU, which allows for the flow of data from the EU to the island, and the way that the island has applied and implemented the EU's General Data Protection Regulation, or GDPR, provides for the flow of personal data from the island to EU member states. Neither the adequacy decision nor our implementation of the GDPR will be affected by Brexit, and the free flow of personal data between the island and the EU member states will still be allowed. Of course, the difference is that the UK will no longer be a member state. But both the UK and the island have taken steps to ensure that we have in place a legislative fix that will allow for the continued flow of data between the Isle of Man and the UK once the UK ceases to be an EU member state. So Isle of Man businesses will continue to have the lawful ability to exchange personal data after Brexit, and therefore allow them to work around any potential problems which may arise.
Supplementary, Mr Hooper.
Thank you very much, Mr President. I thank the Minister for that quite comprehensive answer. I think I'm satisfied that data between the EU and the Isle of Man will be fine. Data between the Isle of Man and the UK obviously will be fine. My question really is, what about data pertaining to EU citizens that has transferred from the EU to the Isle of Man that may then need to be onward transferred to the UK? Is that at risk? Is that still covered by those legal arrangements he referenced that we have with the UK, or is that a separate piece of work? Obviously, the UK will be a non-EU country at that point, and the way the Isle of Man interacts with those third-party countries is quite important from an EU perspective.
Thank you, Mr President. I'm delighted that the honourable questioner has recognised the common sense and legal perspicacity of data protection withdrawal from the EU and Gibraltar Regulations 2019 and the Data Protection, Privacy and Electronic Communications Amendments Act, EU Exit Regulations 2019. That's excellent. But given the complexity and the difficulties of a no-deal Brexit, it is not possible to guarantee that businesses will not face some disruption, and people as well. Hopefully the fact that transfers of data between the island and the UK and between the island and the EU can continue will allow any potential problems to be worked around, whilst there is very little, if anything more, that the island can do to mitigate any problems in respect of the type of transfers that may arise, and indeed any type of transfers not even alluded to by the honourable questioner. We'll do everything we can to make sure that any concerns and any issues that arise are addressed as soon as they can, with the same legal foresight as we've already showed, as the honourable questioner stated in his question.